Welcome to week 7. This week we will start our discussion of hearsay with pages 195 to 206, 209 to 213, 224 to 226, and 238 to 248 in your casebook. The first case that we covered in your readings was Vineyard v. Vineyard Funeral Home. This is a St. Louis Court of Appeals case from Missouri in 1968. For background, on a rainy night, a plaintiff slipped and fell when she had stepped onto a resurfaced and slick part of a ramp in the defendant's funeral home's parking lot. The plaintiff then sued the defendant and was awarded a $13,000 judgment for her injuries, to which the defendant appealed. At issue was whether or not testimony from employees of the funeral home that they had received complaints that the ramp was slippery when wet was inadmissible hearsay. The holding in this case was the appeals court affirmed the trial court's decision, finding that the plaintiff's questions and the witnesses' answers were not hearsay. The appeals court held that the statements of complaints were not being used to prove that the ramp was indeed slippery when wet, which would have been inadmissible hearsay. Instead, they were being offered to prove that the funeral home was on notice of a dangerous condition on its property and failed to change that condition. The next case we cover is Reese Biologicals v. Bank of Santa Fe. This is a United States Court of Appeals case from the 10th Circuit from 1986. In this case, the plaintiff is a medical supplies distributor. The plaintiff was selling supplies to a healthcare provider who was in financial trouble. The plaintiff stopped making shipments to the healthcare provider unless they were able to guarantee payment in cash. They then later resumed shipments on credit after there was an oral guarantee from the defendant to guarantee payments. However, the plaintiff was still not paid in full, and they sued the defendants at trial and won. The issue here is whether the trial court erred in admitting testimony of out-of-court statements guaranteeing payment of the shipments by the defendant. The holding here was the appeals court found that these oral guarantees were not hearsay, but instead utterances with legal effect, meaning that they were offered to show the existence of a contract between the plaintiff and the defendant. The next case we covered was United States v. Kizzy. This is a United States Court of Appeals case from the 5th Circuit from 2017. In this case, the defendant was charged with counts involving firearms and drug trafficking. The police were led to the defendant after arresting Carl Brown. At trial, the prosecutor asked Detective Schultz a series of questions about his interrogation of Brown. Schultz did not testify to the defendant's exact responses in interrogation, but it could be inferred by Schultz's testimony to what the defendant's responses had been. The issue here was whether testimony can be hearsay, even if the testimony is not exact statements of an out-of-court declarant. This court held that yes, the exact contents of statements do not have to be offered to create a confrontation clause or a hearsay problem. Prosecutors will argue that hearsay exceptions apply. In this case, the plaintiff argued that they were introducing the Detective Schultz's testimony about Carl Brown's statements to explain the basis for obtaining a warrant against the defendant, and not to say the truth of the matter. However, the courts acknowledge that there is sometimes a good reason for officers to testify about out-of-court statements for background or to explain their own actions. Again, this would be not for truth of the matter purposes or not for hearsay purposes. However, if a defendant has not challenged the adequacy of an investigation, you could argue that these facts are actually not at issue and therefore unnecessary and very prejudicial to the defendant. During class, we will go over the casebook hypos from page 213, numbers 1 through 3. The next case that we'll cover is People v. Thomas. This is a California Court of Appeals case from the 1st District, Division 4, from 2013. As background, the prosecution presented a police officer's testimony as to payos found on the defendant's cell phone to support the charge that the defendant was a drug trafficker. The prosecution contended that these entries were not offered to show the truth of the matter asserted, but instead to show that illegal activity was taking place. The issue at trial were the defendant's cell phone entries actually offered to prove the truth of the matter asserted, and therefore inadmissible hearsay. The holding of this court was that the evidence was not admitted to prove the truth of any particular transaction recorded on the phone, but instead to show circumstantial evidence that drug sales were taking place. In this case, we wonder, why did the prosecution not argue that even if the cell phone entries were offered for their truth, there was no hearsay issue because they were the defendant's own statements and therefore a party admission, which, as we'll learn, is an exemption to the hearsay rules. The defendant in that case might argue that there was not enough evidence to show that these statements were his, but because they were found on his phone, this wouldn't have been a strong argument. As you'll see from the readings, we will start to discuss the Confrontation Clause. This is where even if hearsay testimony meets the requirement of a hearsay exception and then could possibly come in at trial, a criminal defendant can object on the grounds that the testimony might violate their Confrontation Clause. The Confrontation Clause of the Sixth Amendment reads, "In all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him." The Confrontation Clause can be interpreted in a few different ways. On one extreme, it could be that all hearsay declarants could be considered witnesses against the defendant, and therefore the Constitution would require that the defendant be confronted with them at trial. This would essentially exclude all hearsay. Another interpretation could be that the defendant must be confronted with whatever witnesses the prosecution chooses to bring to trial. So trial witnesses could testify about hearsay declarations, and there would essentially be no limit on hearsay. And then somewhere in the middle, the Confrontation Clause could be interpreted to mean that witnesses against the defendant refer only to people who are available to testify. In this case, the prosecution would be required to produce the declarants for cross-examination when possible, but statements of unavailable declarants could be admitted at trial. The Supreme Court hasn't adopted either of those extreme interpretations, and early cases interpreting the Confrontation Clause do recognize that dying declarations were admissible, despite that the defendant had never been confronted with that declarant. Subsequent cases stay between those two extremes, so not the absolute exclusion of hearsay, and then also not letting every bit of hearsay into trial. A case in 1980, Ohio v. Roberts, established a two-pronged test for satisfying the Confrontation Clause. So prong one was that the prosecution has to produce hearsay declarants or show that the declarant is unavailable. And then prong two is that the hearsay must have adequate indicia of reliability. In the final case that we covered this week, Crawford v. Washington, this was a Supreme Court of the United States case from 2004. For background, the defendant had stabbed a man who had allegedly tried to rape his wife. The defendant and the wife had gone searching for the victim, and when they found him in his apartment, the defendant and the victim fought, and the defendant stabbed him. The defendant was charged with attempted murder, and he pled self-defense. When the defendant was interrogated by the police after being Mirandized and recorded on tape, the defendant and the wife gave different stories about what happened. The wife's story was less favorable to the defendant's defense. The defendant barred his wife from testifying at trial because of marital privilege, and then the prosecution offered the wife's out-of-court statements at trial. The Washington Supreme Court had held that under the then governing standard of Ohio v. Roberts, the declarant was unavailable, and the statements had sufficient indicia of trustworthiness to justify admissibility. The issue was, did offering the wife's recorded out-of-court statements violate the Confrontation Clause? In holding, the U.S. Supreme Court reversed. The court held that the Confrontation Clause does not provide that reliable hearsay is admissible and unreliable hearsay is inadmissible. Instead, it set a procedural rule for how testimony may be given, and that's subject to the Confrontation Clause and if reasonably possible at trial. An out-of-court statement, if deemed testimonial, can be produced against a defendant only if, 1, he has had the opportunity to cross-examine the declarant, and 2, that the witness is unavailable to testify at trial. So the question here is, what is testimonial evidence or testimony? Later cases address this question, but in Crawford, the wife was giving statements to the police with a warning that her statements might be used against the defendant at trial. This is clearly testimonial. Next week, we will continue to discuss hearsay and hearsay exceptions.